Employment Law This Week. I'm George Whipple. Whistleblower protections are increasing across the country. The California Supreme Court recently relaxed its standard for proving whistleblower retaliation. And effective in January, New York dramatically expanded whistleblower protections in Section 740 of the labor law. Over the past decade, retaliation claims have become the most common type of claim filed with the EEOC. Epstein, Becker, Green's Greg Keating and Daniel Green are here to tell us what the current climate means for employers.
There's three drivers which are really causing retaliation and whistleblowing claims to explode around the country right now. The first is the advent of new laws, which states and the federal government are passing at a rapid clip, designed to enhance liability and risk and provide new remedies for whistleblowers for retaliation. Second, we have a stepped up government enforcement. The Department of Labor, EEOC, and NLRB have decided to join forces and issued a joint initiative that they are coming after retaliation in the workplace with stepped up penalties and new enforcement mechanisms. And then finally, huge awards, jury verdicts, as well as whistleblower awards under programs like the SEC and the CFTC. The SEC just passed the $1 billion with a B dollar mark of new awards being meted out to whistleblowers. And this has caused a galvanization of the plaintiff's bar and increased risk for employers around the country. In terms of what should be in that policy, I would note at least three things. The first is multiple reporting channels. Employers need in today's world to offer their employees a variety of portals, of mechanisms through which they can complain, whether it be live to their frontline supervisor, to HR, to internal audit, or online through a web-based portal or a phone-based reporting mechanism. Secondly, whistleblower policies should encourage confidentiality under the circumstances, that we will take every inquiry seriously, and to the extent practical under the law, we will ensure to protect confidentiality. And finally, a commitment against retaliation. Workers need to know when they complain that their complaints will be taken seriously, but also that there won't be reprisals for coming forward. We strongly recommend training across all avenues of the organization, starting with the C-suite and going down to the rank and file employees.
New York substantially revised New York labor law section 740, which previously had been a rather narrow statute protecting people who report specific threats to public health or safety, and turned it into a general law protecting employees or independent contractors or former employees who report unlawful conduct to either their supervisors or public agencies such as regulatory agencies or law enforcement. This essentially creates a general whistleblower protection in New York, which didn't previously exist. It also eliminates a lot of the procedural issues which made it easier to defend whistleblower protection claims previously. Amendments also include requiring employers to post notices of protections under the law and protecting employees who make good faith reports of suspected violations of law rather than requiring employees to report actual violations, meaning that under the prior law, employees who thought they were reporting a violation of law but the employer was engaged in legal conduct lost the protections of Section 740. We should expect additional states to continue this trend, and employers will be well served to implement whistleblower anti-retaliation policies, as well as training regarding those policies, regardless of whether they do business in New York or another state with similar protections.
Thanks, Greg and Dan, and thank you very much for watching. We'll see you next time.